We can begin. First of all, I would like to greet all colleagues who participate in the fourth student conference on legal history. The title of this session is Contemporary Perspectives on Punishment. And before we start, I would like to present myself. I am Valentina Cvetković Đorđević, the professor of Roman law at the Faculty of Law, University of Belgrade. In this 8th session, we have a mosaic of different topics. All presentations, I'm sure, will be very interesting. So as Nina Kršljanin, my colleague, said before the break, we will first begin with two colleagues, Anastasiya Rudak and Kseniya Taranova from Belarus state, and they will say something on punishment as a measure of salvation of inner self. I cannot see them here on the screen, so I suppose that there is some problem in connection.
We're here.
Okay. It seems that everything okay. Two colleagues, they are from Belarus State Economic University, Faculty of Law, and I hope the next time you will be here with us in Belgrade. So the word is yours.
Yeah, I hope so. So good afternoon, dear colleagues. We are glad to see you. Thank you for the understanding. We are going to tell you about punishment as a measure of salvation of the inner self. So now, can you see our screen?
Not yet, but it's starting. Yes, we can see the text now.
Okay, great.
Just zoom in, please, because some people are sitting pretty far from the screen here, so maybe you can flip a little more if you can. I don't think so. Make it page wide if you can. Yes, wonderful. Thank you.
Okay. We will start. The definition of punishment in science and everyday life is associated with the concept of crime and misdemeanor. Without crime, there is no punishment, but if there is no punishment, crime rate will increase exponentially around the world due to the peculiarities of modern society. However, any system has its flaws, and the punishment system is no exception. The main problem of punishment is its comprehension as an integral part of the legal reality, the assertion of its purpose. This issue includes such aspects as freedom and responsibility, guilt, good and evil, repentance, and redemption. Due to the fact that at this stage there are a considerable number of opinions and points of view, the concept of punishment is rather ambiguous, and its general form punishment is understood as a measure of criminal legal influence applied by court, sentenced to a person convicted of a crime, and consisting in the deprivation of restriction of the rights and freedoms of the convicted person as provided by law. Despite this interpretation, the legislation of many other countries and works of scholars contain different formulations. This happens due to the centuries-old evolution of punishment and its history. If to speak about the formation of the institution of punishment in historical terms, the following should be noted. In different historical epochs of the Belarusian state, criminal punishment had its own specifics. Criminal punishment had its own specificity at different historical epochs of the Belarusian state. The earliest surviving written monument of the penal institution of punishment is the Treaty of 1229 between the Vitebsk, Polotsk, and Smolensk regions and the city of Riga and Gothic coast. No less important stage in the formation of the system of punishment was the application of the principle of talion, an eye for an eye and a tooth for a tooth. Thus, punishment had a private gratification nature and then was replaced by a blood feud. However, over the years, the punishment became public with the aim of protecting society from the criminal. Thus, in 1468, Kazimier's Code of Laws was formed, which not only established new subdivisions of crime, but also provided for the death penalty by hanging. This was the first time the idea of intimidation was enshrined in law as one of the main aims of criminal law. Previously, under customary law, the offender could pay off the death penalty or be handed over to the victim or his relatives as a slave. The judicial code prohibited the release of criminal form punishment, and there is no need for mercy over the villain. The Statute of the Grand Duchy of Lithuania of 1588 laid down new provisions of criminal law. It regulated the subject of criminal law, delimitation of international and careless guilt, innocent perpetration of damage, and etc. The principle of presumption of innocence, which provided for the interpretation of doubt in favor of the accused, is the principle of fair punishment, were the main innovations. Historically, the evolution of the institution of punishment and the system of punitive measures is characterized only from a formal point of view. This means that punishment has acted as a way of dealing with consequences. However, what is the root cause of the unlawful acts that lead to the imposition of a certain punishment producer on a person? What is the psychological aspect of punishment? In the modern world, there is a special direction of psychology which studies the psychological basis of resocialization. Correctional psychology. The essence of this direction lies in the restoration of previously disturbed social qualities of an individual, which are necessary for his full functioning in the society. However, the approach characterizes the evolution and system of punishment only from a formal point of view. It means that punishment comes as a way of dealing with the consequences. But what is the root cause and what is the psychological aspect of punishment? Correctional psychology studies the psychological basis of resocialization, restoration of previously disturbed social qualities of the individual that are necessary for its full function in the society. On this basis, psychology studies the problems of effectiveness of punishment, personality dynamics of convicted person in the process of sentence enforcement, formation of his behavioral features in different conditions of camp and prison regime, especially value orientations and behavior patterns of a small group in conditions of social isolation, compliance of current legislation with the objectives of correction of prisoners. Fair retribution is a measure of social reaction for individual departure from the socially permissible boundaries of behavior. Civilized society rejects the talion of the past. The aims of punishment refer to the final social results that can be achieved through the establishment and implementation of punishment produced in the criminal law. This includes restoration of social justice, correction of convicted, prevention of committing a new crime, and etc. So the purposes that can be solved by the use of punishment include neutralizing the painful main frustration of crime, lowering the threshold of its influence, and protecting society from crime and criminals, and etc.
In the modern world, science contain a mention of punishment imposed for a certain crime by the court is based on the conviction of the court in the necessity and sufficiency of punishment for correction of the person who was committed a crime, prevention of new social dangerous acts posed by the convict and other persons, and also restoration of social justice. However, full fight Sigmund guilty of punishment is necessary to take into account psychological condition of the guilty, namely psychological analysis of typological features of behavior of offender, and first of all, those mental qualities which determine socially significant features of his behavior is necessary.
After all, there are the certain of origin of ideas or beliefs about committing crime. One of the most emotional and socially relevant elements is moral behavior. Repentance is a key moment that is basis for awakening a person's conscience for the correction and restoration of personal moral self-control. Repentance and rudeness to can allow a person to gain a new perspective in life and return to the worst life. Some psychologists argue that severe and or unforeseen punishment can cause seriously personality change up to and including mental illness. Society has become accustomed to the fact that consequences is primarily the mainstay there is subject to any kind of impact under any condition. It's impossible not to agree with these stereotypes. However, the state of the soul, namely the spiritual psychological component, requires no less attention. The behavior of people can be controlled by fear. Man is a proud and independent creature, and the more primitive the mental organization of the individuals is, the less he's concerned about the moral side of the means he used, the less he calculates the harmful consequences of an act which is beneficial to him. Rewards and punishment government human behavior is a famous sociologist Tim Sorokin. Modern dictionaries don't provide an answer as to what constitutes correction. From our point of view, to correct an offender means to change those mental qualities of the offender that determine his criminal behavior. In order for modern correctional institution, here and after CI to become institution for resocialization of convict, they themselves should be resociated. The general direction of resocialization activities of CI are as follows. The first is the psychological diagnosis of personal features of each inmate, identification of specific defects of the general socialization, legal socialization, as well as defects of their mental self-regulation. The second is development of a long-term program on individual, personal, psychological, and pedagogical correction. It's step-by-step implementation. The third is implementation of necessary measure of psychotherapy, relaxation, leveling of personal execution, expectations, psychological manifestation, removal of all kinds of psychological barriers, manifestation, and psychological protection. The first is development and introduction of new principles of the regime, its profound humanitarianization, and the fifth, the full restoration of disrepaired social ties of personality, mobilization of its mental activities, formation of social positive sphere of its current and prospective well-being on the basis of socially positive value orientation. The principle of the need for resocialization necessitates the introduction of a course of psychological help, and it reflects in the writings not only famous scientists but also thinkers and writers. The criminal who rebels against society hates it and almost always considers himself right and its fault. Before something can be corrected, one must know what is broken. Throughout Kulfati's psychodiagnosis, it's impossible to correct any personality. Does it really need to be corrected? A number of basic mental qualities of personality of offender shouldn't be corrected, but reshaped. Crime cannot be rejected by mere raids and serious alone. However, it can be considerably reduced by changing the condition causing it and by changing the anti-structure to the methodology of the work of correctional institution. There is a need to introduce mandatory psychological support for person serving sentence of restriction of liberty, imprisonment for a certain period of time, and life imprisonment. This novelty will contribute to the internal elaboration of the attitudes of individuals' consequences, because in every development of knowledge, the new areas only on the basis of the old as a cognitively deeper, more meaningful, and more adequate standards of comprehension and understanding. To correct a guilty person is to reorient him or her in terms of values to include in the sphere of his or shame and confidence the social value he or she was reality. The task of contemporary society is to find the root case and to prevent the consequences, not only result of wrongdoing. After all, everything starts from within. Thank you for your attention.
Yeah, thank you for your attention.
Sorry, always problems with technology when I'm in front of you. I suggest if somebody has a question, because our colleagues from Belarus should leave earlier, can now raise the question. The topic is very interesting in terms of the essence and the purpose of the sentence, because I would like to recall one case from the Serbian practice. It happened a couple decades ago when one delinquent who committed a murder, and he was sentenced, I think, 20 years in a jail, was released he got one free weekend after serving 18 years of imprisonment. And during this free weekend, after 18 years spent in a jail, he committed a new crime. And after that, I think he was sentenced to death. But in the meantime, the code was changed, and I don't know what happened, if he is still in the jail or no. So I would like to ask the question to all of you: what is your general opinion concerning the possibility to change, to make a person better than he was before committing the crime? So please, if somebody wants to say what is his personal opinion. Our colleague from the Faculty of Law University of Belgrade.
It's interesting, Professor, that you mentioned this, because many countries, Northern European countries that were probably the most liberal in terms of helping the prisoners get better and not punishing them, are slowly, like, let's say, a little bit abolishing that principle in last few decades, because they saw that it can be pointless in certain cases, as in the one that you mentioned, and that's from our domestic law. But people are like that are not exclusive for Serbia or for any other country. It's something that has to be studied really deeply and mainly psychologically, I think, because law really can't help in law can't always help in that cases. And I think that the best signal that law can't really prevent people from repeating their crimes are those countries that were on that course and are leaving it little by little last few decades, mainly Sweden, Norwegia, and so on.
Thank you. Our colleague also from Serbia, Isidora, first.
Thank you. Well, I think it is possible. A criminal punishment mustn't be just a retribution. Rehabilitation is also one of the principles of criminal law. So it is possible for some people, yes, for some people, no. But it is something that we should look forward to, and the regulation must be ready to make the rehabilitation of prisoners easier. The society needs to accept the prisoners who had left the jail and all other punishments too. So that is my opinion. Rehabilitation is possible. It is a part of the act, a part of the person who committed the act. Thank you.
Thank you. The next.
Well, I would agree with Isidora, because if we wouldn't think if we would think that there is no possibility of rehabilitation, of resocialization of the prisoner, then there is no reason to have any other prison sentence than a life sentence. Because if we don't believe the person can be resocialized, then we really shouldn't let him out of the prison. So yes, it probably doesn't work always. It might not work even in most of the cases, but still the point is to try to do so, because at that moment we would have to change the whole punishment system.
Yes, thank you. I suggest only before you raise the question, just to present yourselves, because maybe colleagues from Belarus couldn't follow all your names and your origins. So thank you. We have another comment or question.
There is faculty of your University of Belgrade. The rehabilitation is possible, but rehabilitation is not certain. Rehabilitation is possible in many cases, and I am opposite about death penalty, about that, but some criminal legislations think that rehabilitation is not only things, and abandon rehabilitations, because rehabilitation in some cases is impossible, and rehabilitation is one of the value of criminal penalty, not the first for me.
Thank you.
As for the Russian theory of criminal law, also we put it like a goal for all the time till Soviet period to correct the criminal, to rehabilitate him. But nowadays the official goal, and only one official goal of our theory of criminal law, is to prevent the commission of new crimes. So we don't today, we don't think that criminal law can correct and rehabilitate the criminal.
Thank you. But we are faced, as far as I know, I'm talking about the situation in Serbia. I'm not acquainted with the situation in other countries. We are faced with a very negative trend. The public, for example, it happened a crime, and the public via Facebook, Instagram, because nowadays it's very easy to use and to make public to everybody what happened. They simply seeks for a person who uses Facebook, or this is unfortunately a plenty of persons. They simply seek for revenge, and they want to. You can. When I read very often, I can see that the people are really, if I can say, the people are interested in getting a revenge. They don't have the sense that we can contribute to common good, or to try at least to prevent people, as all of you, I suppose, agree with me, think it's necessary to prevent crimes, not to again implement the principle of talion, because it goes back to very old times. So in the meantime, I think there is a civilization, and we also are faced with some new knowledges in the field of psychology and other social sciences. But I'm very disappointed what happened. So this public is simply how to say, like in Roman times, when you had a lot of people, plebs, who were gathered in Colosseum and in arena. to see the blood, to see simply the revenge. So this is the problem here, and it happens that the policy of sanctioning it goes together with this common opinion. So we now have some how do we call it when a lot of people sign for a petition? Yes, thank you, for petitions to increase the severity of some punishments, and simply jurists, professional jurists, and practice is unable to fight against those public opinions who prevailed, unfortunately. So we will see how will be the perspective of sanctioning those crimes here, but if it prolongs like it seems nowadays, we will have definitely a big problem. Colleague wants to.
I absolutely agree with you, because the social media, Facebook, Twitter, is big enemy, is the biggest enemy in the criminal law, because they create public relations, they create public reactions, and someone committed a crime, and the public has created unpleasant situations for him, and for me this is the big reasons that we have some worst results in rehabilitations in the last 20 years than before, because social media.
Yes, unfortunately, during the communist time, the policy of sanctioning was how to say, more plausible according to nowadays professional and scientific knowledge. So nowadays we have exactly the problem of very severe sentences, and on the other side there is no prevention at all. So we cannot achieve any goal we really need to achieve. So that is the problem. So Nina maybe want something.
Well, not a comment of my own, but I heard someone start to speak online, so maybe our Belarusian colleagues wanted to reply, or maybe someone else was trying to.
Yeah, thank you for your point of view. Thank you for your opinions. It was really interesting to hear your points of view. So, and as we have already said, everything starts from within. So, and the main purpose of law, of course, we would like to prevent the crime. But if in our society we won't work on our character, on our inner world, so what would happen this way? So in our opinion and in our work, we're trying to illustrate that it is very important to start from within, from our inner self.
Good. I think it is one possible way to cope with the problem, which has lasted forever, it seems. Thank you very much. If you agree, thank you once again.
Thank you so much.
And as I said at the beginning, I hope we can meet next year or next years here in Belgrade in presence. So I wish you all the best in your future work.
Thank you so much. Have a nice day. Bye-bye.
Thank you. So now we go to our colleague, which comes from the University of Szeged, Faculty of Law, Dr. Denis Legeza.
Thank you very much.
Can we hear you? Yes, I see you.
Yes, perfectly. Thank you very much.
Welcome. I just want to say the topic of your presentation is criminal law consequences of copyright infringements.
Yes, thank you very much. Could you make me a host or co-host to share my presentation?
Uh-huh. Mm-hmm. I cannot see presentation. Exit.
Change role, make presenter.
I make presenter.
You should be able to
Yes,
now.
perfect. Yes.
Thank you.
Okay. So now you can see. So good afternoon to everyone. First of all, I would like to thank the organizer of this conference for accepting my paper and invited me here today. I try to be very short because I know that in a short time you will have your lunch break, maybe in 40 or 50 minutes later. So allow me to begin my presentation with a short story which sums up what I'm talking about today. Of course, copyright infringements are much lighter crimes what you were talking about in the last few hours or few days. So, according to an anecdote, King Ptolemy III had a writing competition in the Library of Alexandria, where 6 members of the jury awarded first and second prizes to the authors most popular with the public. The 7th member of the jury was Aristophanes of Byzantium, who, contrary to the other members of the jury, he liked that author who did not steal from works of others. To prove his claim, Aristophanes quoted plagiarized sources from memory. The king eventually made Aristophanes head of the library in Alexandria and banished the poets who had plagiarized. Of course, we know that in antiquity, plagiarism was not punished so severely, but plagiarists were morally despised. In my presentation, I will analyze the consequences of Hungarian copyright infringement from several angles. First, I will show you why the Hungarian legislature decided to introduce criminal and civil sanctions against copyright infringers in the 19th century, and why the Copyright Act contained all the provisions. In this section will be presented the progressive nature of the regulation as well. Then I will present you a special legal institution, the body of copyright experts, and finally I will show you some case law as an example. Starting my main topic, let's see a timeline. The timeline shows you the development of copyright-related regulatory in Prussia, Germany, Austria, and Hungary. Why these countries? Very simple. In a very simplified form. Everything that the Austrians wanted that the Hungarians should do, we prefer to copy the Prussian-German solution in protest against them. So that's why most of our laws from the 19th century are based on the German solutions and not on the Austrian solution. If we look at 1884, there is a slight red line. When the first Hungarian Copyright Act was entered in force, we can see some observers. But first, you can see that in the top of the slide, these are the Prussian, German publishing and copyright regulations. Then in the middle, you can see Austria, and in the bottom of the page, you can see Hungary, where are other subsections like civil law, law of obligation, copyright law, criminal procedure, and civil procedure law. So if we see 1884, you can see that there was no civil code. We had commercial code, which has regulated the publishing contract before the Copyright Act. And the criminal code and civil procedure code were already in effect, but modification of those type of codes in that time was not so easy. And also you can see that there was no criminal procedure code. So this means that the new Copyright Act would either have to amend all existing law or create a new one. So that's why the legislator thought that it's much easier to put all the substantive and procedural regulations in the new Copyright Act. So if we move on, we can see that these are just some selected articles from the first Hungarian Copyright Act in 1884, that the criminal law offense, the penalty, and the jurisdiction of the civil court were regulated within the Copyright Act, and civil court decides in copyright infringement cases in criminal sanctions as well, not just civil sanctions. In addition to substantive law, the Copyright Act of 1884 and its ministerial decree had procedural provisions I have already mentioned, and that's why the legislature could put some new solutions within the Act, not to follow the already existed one. You can see here we had a very old Code of Civil Procedure for 1868, written procedure, formal taking of evidence. So that's why it was new in copyright legal action, that principle of freedom of proof, or principle of free waiving of evidence. It was a new invention for this period, and later, of course, the general civil procedure also changed and followed these modern, so-called modern principles from 1911. If we move on, there was a new, let's say, new legal institution in this act. These are the experts in the Copyright Act. We could see that there was an expert institution in Budapest and in Zagreb, and there were scholars, writers, artists, booksellers, printers, and other qualified persons who could help the judge in different copyright cases. We can see here that the history of the Board of Copyright Experts goes back to the 19th century Prussia, if we do not count Ptolemaios and Aristoteles from the third century before Christ. The first known expert opinion was 1822 by the famous writer Ernst Theodor Amadeus Hoffmann. And a few years later, the Prussian Copyright Act had this provision that in different cities of Prussia, there should be an copyright expert institution or association. And of course, because we copied the Prussian Copyright Act in our first provisions, in first bills from 1844 until 1884, we have this institution. This institution was in the German Copyright Act until 1935. So you can see that this institution lived in Germany for almost 100 years. And in Hungary, it's almost 150 years old. If we move on, we can see that these experts usually seated in the Hungarian Academy of Sciences, and whenever the court needed some expert opinion, this institution gave the outcome to the judges. What was the main role of this expert institution? One of a very famous Hungarian criminal lawyer, Bertalan Szemere, explained in this justification to his bill in 1844 that the infringement often takes place by the adaptation of mere forms. The judge often has to draw a line between the ideas of others and their own within a single copyrighted work. Citing his illustrative analogy, you need to know the stolen gem in great detail, as they wanted to disguise it by mounting it on another ring. Perhaps the peculiarity of the work of copyright expert is that it is difficult to draw the line between technical, factual, or legal issues. In my third part of my presentation, now I will show you some cases from the 1930s, but of course, you already mentioned Instagram, Facebook, and so on. So nowadays, this is my summary as well of my presentation, that these cases 100 years ago almost the same like we had nowadays, what memes, artificial intelligence, and so on makes on the digital era as well. So the first one is about the idea versus expression dichotomy within the copyright law. There was a great rayon lining called Bamberg silk in the 1930s, which was produced by the Goldberger textile factory in Hungary. They were looking for graphic designers to promote the new product. As usual, the loser sued everyone, the textile factory, the owner, and the other graphist as well. According to the facts, the idea and purpose of both the plaintiffs and the third defendant's work was to express and illustrate in a poster the desire of a woman longing for Bamberg silk. You can see on the right side. The plaintiff brought an action against the textile factory because he claimed the poster, the right side, showing the factory's product was based on his concept. The lawsuit revealed that the company had commissioned the graphic designer to use its own earlier poster, you can see on the left side, so no copyright infringement could have occurred. So both left and right-handed posters were created by one graphist, Laszlo Nemes. The court stated that in any event, copyright law does not cover the idea itself, but expression or embodiment of the idea in a work of art. If we move on to the next case, is about public performance. One of the main economic rights is the right to perform in public. This copyright is primarily in the case of theatrical works, choreographies, and of course musical works. It took a long time before the public performance of musical works was subject to the payment of royalties by the catering trade. But turning point came when the Royal Curia, the Hungarian Supreme Court, ruled that in the case of an unauthorized performance by an orchestra, a gypsy band, playing in a cafe or restaurant without prearranged program, the cafe or restaurant owner may be prosecuted for copyright infringement in order to pay damages on the grounds that he has hired the orchestra to play. So I'm also convinced that in Serbia and other countries, there are always, let's say, problems that public places who use music has to pay royalties to different collective management organizations. But the source in Hungary for this legal action is that court rule from 1918, and after this time, all the aforementioned places had to pay royalties. And finally, this last case is about the right of attribution, also from the 1930s. So I think not just plagiarism, but not to use someone other's name as an author, also everyday problem nowadays as well. So in this case, there were two neighboring traders in the center of Budapest. One was an inventor and hairdresser, and the other was a photographer. So one of the hairdresser's inventions was an electronic curling device, which was patented by the Hungarian Patent Office in 1930. In the next year, his hairstyle won the first prize at the first national long-lasting waving race. He used his own invention for this hairstyle. As a winner, he asked his neighbor to photograph, to take a picture of the winning model. The hairdresser sent the photo to the magazine called Theatre Life with an announcement, but the magazine forgot to indicate the photographer's name, so the photographer sued the newspaper because of the infringement of the right of attribution. But finally, the court said that he should have sued his neighbor because the hairdresser sent the picture without his name to the newspaper. So in a summary, I showed you how much needs to be taken into account when codifying a new area of law. And I know that, however, copyright infringement is not a large-scale crime, but it is protected in many countries in parallel by criminal and civil law sanctions, mostly because intellectual property or copyright crimes, usually this is the entrance when you can have some money and later they can cause much bigger crimes. And if it is not possible to amend the complementary legislation, then the lex specialis should be used. And finally, have shown that there is nothing new under the sun. Great many copyright cases today are still about the same life situation as 100 years ago. So thank you very much for your attention.
Thank you very much, dear colleague. I would like to ask for comments, questions. Thanks to Gutenberg, the scope of possible infringements in this sphere is enlarged. Our colleague with always smart questions, I must say.
Thank you for your presentation. It was great. I found it the most interesting, the differentiation between the idea and the expression. It may not be strictly legal historian question, but I'm interested, does this apply only to arts? The differentiation between idea and the expression, or you could apply this differentiation to, let's say, technical innovations as well? Hope I'm clear enough.
Yes, in general, ideas cannot be protected, not just in the European Union or by international treaties as well. Of course, if there's some, if we are not talking about copyright, but from industrial property or patent, we can say that it can be part or subject of trade secret. So that's why usually if you have a patent and you filed all the documentation, which later will be published, disclosed on the internet as well 1.5 years later, all the knowledge you can do what the patent drawing or the wording of the patent is written. But sometimes some ideas are hidden between the lines, and you cannot do it. But if you use the same technology, what is in the patent documentation, you will infringe the patent law. But if you just want to solve the same problem a very similar way, which is not the same exactly, it won't be a patent crime. So that's why if you have some technological idea, it's very important at the beginning to choose to be a secret, or if you patented it, someone is they are a clever person, they can switch your patent, and they can use another solution for the same way. So that's why not every solution is good to be patented. I hope I could answer your question.
Clear enough. Thank you.
Thank you very much. Some other question, comment? If there is no, I
Thank
would
you very
like
much.
to thank you again for this nice presentation, and in any case, very, very interesting. Our next presenter is the colleague from Warsaw, University of Warsaw, Faculty of Law and Administration. Her name is Sara Anna Kubicka.
Hello, hello everyone.
Hello.
I have a presentation. I just need to have a role of presenter to present it, I guess. Um, hmm. I'm still not able to share my screen with you.
You should be. I think Valentina just made you presenter. So
Yes.
just maybe start over. Click share,
Hmm.
and then you select the window with the presentation and click share again.
Yeah, but it still shows me that you can share the content.
Okay, let me double check.
I can also send the presentation to you real quickly. So if there's any trouble still.
Yes, but I think. Okay. Did you click on her? Probably didn't. Maybe you made someone else. Try
Okay,
it now.
I guess it works right now. Yes.
Great.
Yes, great. Sure. Okay, I hope you see everything clearly. Oh,
Yes.
it's not that
Just
present.
if you can full screen it.
Yes.
Yes.
Of course. I hope it works right now. Yes, everything is visible for you?
Yes,
Yes,
everything
yes.
is visible.
Okay.
As the colleague can see, the title is Deprivation of Liberty and Mental
Yes.
Health,
Thank you very
Contemporary
much.
Challenges and Standards.
Yes. Good morning, everyone. My name is Sara Kubicka. Thank you very much for welcoming me and for the opportunity to present my paper. I would like to quickly apologize if I sometimes have trouble catching my breath. I'm at the end of my COVID infection, and I appreciate all the more the opportunity to connect with you remotely. And moving on to the paper. In my speech, I would like to address the complex topic of the mental health of perpetrators of acts prohibited by law and the possibility of enforcing deprivation of liberty against people with mental disorders. I will discuss it from a legal perspective, as this is my only scientific perspective. At the same time, knowledge of the legal regulations shaping the prison system in Poland makes it possible for me to present this issue through the prism of the law's function as an essential tool to help deal with the problem. The opposite can also be true. A law that does not function properly can exacerbate the problem. Although humanity has questioned the possibility of enforcing criminal liability against people with mental disorders for years, it remains one of the most difficult challenges for modern criminal legal systems. Nowadays, in Poland, insanity is one of the circumstances excluding guilt, which means that in order to be able to talk about attributing criminal responsibility to a person for an act committed, it is necessary to first assess his conduct from the perspective of Article 31 of the Polish Criminal Code from 1997, which reads, "A person who, due to mental illness, mental retardation, or other disturbance of mental functions, was unable at the time of the act to recognize its meaning or direct his conduct, does not commit a crime. And if at the time of the offense, the ability to recognize the meaning of the act or to direct one's conduct was significantly impaired, the court may apply extraordinary mitigation of punishment." Thus, in Poland, liability depends not so much on mere existence of a mental disorder, but requires recognition of two issues. Firstly, the extent of the disorder, and secondly, the extent to which the disorder may have influenced the person's behavior when he or she committed the offense. Guilt, understood as the perpetrator's attitude toward the act, is a well-established concept in modern legal systems. However, it is worth noting that as late as the beginning of the second millennium, objective liability, independent of guilt, prevailed widely. Criminal responsibility was linked to the effect of behavior, regardless of whether it was possible to attribute guilt to the one who caused the effect. Historians indicate the medieval period as the moment of linking punishment to guilt. They attribute this merit to the influence of canon law, for which the concepts of sin and atonement have a much deeper meaning, not limited to mere reparation for the act committed. The subjective understanding of guilt made people think about the morality of holding a person unaware of his actions criminally responsible. Over the years, thinkers created various tests to distinguish between crimes consciously committed by healthy people and acts whose perpetrators, due to mental illness, could not direct their behavior rationally. It was important to select appropriate methods to deal with ones or the others. In the old days, people looked for the genesis of mental illness, so to speak, outside of the person. They thought of insane people as possessed by demons, and until the 19th century, people assumed that mental illness caused criminal behavior, and there was no clear distinction between criminal and sick behavior. Sick people usually end up in ordinary prisons or insane asylums, as the one portrayed by Goya. And these institutions had inhuman conditions and served isolation rather than a treatment function. Over time, insane asylums gradually began to be replaced by places where people with mental disorders could get more adequate help, the archetypes of modern psychiatric hospitals. Mental disorder can occur on different scales, but their severity will not always occur when committing the criminal act, and they may already appear in prison. According to the former Ombudsman's 2019 speech on proposed changes in the treatment of mentally ill prisoners, there are still situations in Poland in which sick people, despite the disclosure of their illness and the opinion of psychiatrists, has not been released from custody for treatment. And the Polish Executive Penal Code from 1997 explicitly states that in the case of mental illness, the court shall grant a break in the execution of the sentence until the obstacle ceases to exist. Thus, there is currently a lack of effective measures to address the problem promptly. The rights of inmates are a danger and they are not guaranteed, as the presence of people with mental disorders in prisons can pose a danger to, firstly, themselves, secondly, fellow inmates, and lastly, the prison staff, who are unqualified to work with people with mental disorders. However, the mental health problem is not closed by the distinction between situations in which a person should be in a psychiatric hospital and those in which he can serve a prison sentence. For those who find themselves in prison, the facility should be a place that will enable a proper return to healthy functioning in society. Adequate psychological support is, in my opinion, a total aid in this process. For a long time, until the 19th century, imprisonment was repressive rather than corrective. It was only when the meaning of the purpose of punishment changed that deprivation of liberty began to occupy an increasingly important role in the catalogue of punishments. A new perspective on the treatment of prisoners is due to the birth of humanitarianism in 19th century Europe and the criticism of the inhuman conditions in prisons. One of the earliest proponents of a humanitarian approach to prisons was John Howard, who published The State of the Prisons in England and Wales in 1777. Howard visited prisons and describing the conditions in them. The 19th century was when were built first prisons, which, while they had many flaws, represented a certain breakthrough in the ways in which prison sentences are served. One of the most famous was the Eastern State Penitentiary, established in Philadelphia in 1929 and considered to be world's first true penitentiary. It is very popular because of the fact that prisoners were alone serving their sentence, but it is very interesting and not so common to know that prior to its closing in 1969, Eastern State Penitentiary had established a far-reaching program of group therapy with the goal of having all inmates involved. When the plan was initiated, the program appears to have been moderately successful, as many inmates were voluntarily involved in the groups. The groups were led by two therapists. Firstly, one from the psychological or social work, and also the second from a prison officer staff. The more human approach to treating prisoners became popular in the following decades, resulting in reforms to improve the living conditions of prisoners. In prisoner rehabilitation, therapy plays a significant role for a longer time. However, the 1960s are the beginning of recognizing its importance. Scientists then noticed that prisoners who participated in therapeutic programs were much less likely to reoffend. One of the best-known studies on the effectiveness of therapeutic programs in terms of rehabilitation was the experiments conducted in 1960s and 1970s by Canadian psychologist Donald Andrews and his team. The results clearly indicated that therapeutic programs could help reduce the risk of a return to crime. So they began implementing prison programs to help inmates with addictions, emotional disorders, and other problems that can contribute to crime. Today, therapy is widely used in penal system and helps prepare for a return to society after leaving the prison. Therapy can help inmates understand the causes of their behavior, learn healthy ways to deal with their emotions, and develop social skills. It is worth noting that imprisonment is not indifferent to a person's mental state. An inmate may feel isolated from the rest of society, limited in his ability to move around, and unable to make independent decisions and control his own life. Stay in prison is often associated with the atrophy of social ties, while experiencing an entirely new prison reality and interpersonal relations. All this make it very important for the prisoner to receive adequate psychological support during and after serving his sentence. A penitentiary psychologist in Poland often has more inmates under his care than the standard indicates. And what is the standard? There should be 200 inmates per penitentiary psychologist. This standard significantly deviates from the need to provide adequate psychological assistance to inmates. It is impossible to fulfill the task incumbent on psychologists working in detention centers and prisons, assuming that one specialist in his field has to take care of 200 inmates. Even assuming that not every inmate will be willing to take advantage of any form of psychological assistance, the standard still in force does not guarantee inmates a proper support system. According to the law of August 19, 1994 on mental health protection, mental health is a real personal good of a person. So it is necessary to increase the availability of psychological assistance for people deprived of their liberty and to ensure that psychologists have proper working standards. The evolution of imprisonment shows that prisons were often inhuman in their past, and an inhuman way of treating prisoners increases the risk of deterioration of their mental state. However, modern standards ensure prison systems focus more on rehabilitation and return to society than punishment. While advances in mental health and psychiatry have brought many positive changes in recent decades, caring for the mental health of those who have committed acts prohibited by the law remains a significant challenge. People deprived of liberty experience a range of adverse effects of punishment on their mental well-being. At the same time, there are still situations in which people who suffer from severe mental disorders and require psychiatric treatment end up in ordinary prisons not equipped for psychiatric care. Without the past, there is no present and there is no future. The past has taught us that so much, and the present verifies this learning. The question is the future, which we do not know and can only look forward to by challenging it based on experience. For me, the future of prison system is to ensure that people deprived of their liberty have access to the necessary care, both in prison and after they leave the prison, to facilitate their return to healthy functioning in society. I believe that therapy is not just a support for offenders. Nowadays, it's even a luxury to be able to participate in therapy. For me, it's also a challenge to work hard on their psyche. History has taught us that, as the Polish writer Gustaw Herling-Grudziński once said, man is human in human conditions. Therefore, I believe that to see in man, we must provide him with the conditions to be human. Thank you very much. Mnogo wam chwala.
Thank you. Thank you very much for this very interesting presentation. And we again come to the topic of guilt, the concept of guilt, and the purpose of the judiciary sentence. What is the purpose of the sentence, if at all can be issued? Because when we deal with mentally disordered people, we could not sentence them in terms of criminal law. I would like to, before I give the word to our colleagues, all the time I have in mind delinquents of sexual delinquents. So experience shows that many sexual delinquents constantly repeat the same delict. So the big question, how can we cope with this problem? Is it possible to change their mind in a sense that they can really appreciate the value of the freedom of sexual intercourse voluntarily, or no? So I would like to hear Anna, Sara, your personal opinion, and what can you suggest us concerning this special group of delicts?
It's a really hard issue, because in Poland we didn't manage to cope it in a human way, because I didn't have enough time, because it could be another presentation, but we had a very interesting situation in Poland with prisons who, after serving their sentences, they were sexual criminals. They were placed in Gostinin, which is a place not exactly created to help them, just to isolate them from the society. And they were placed there after serving their sentence, because they were still acting in ways, and people who were taking care of them, seeing that they are not able to return to the society because they can reoffend. And I guess there are many mental disorders where the prison is maybe not able to help them, and sometimes you're just not able to help someone. But I still believe that you should believe and give them a chance to try to work on themselves. And I really want to believe that they are able to become better and stop being dangerous for the others in the society. Maybe the therapy is the best option for them. Sometimes maybe the psychiatric therapy, not just psychological support. Yes, in Poland we still have problem with it, and I believe it's the challenge for the future to find a solution, maybe to help them.
Thank you very much. I'm very glad that all of you have optimistic view, and that you somehow retain this humanistic characteristic of what is, from my point of view, the essence of a human being. So thank you. I would now like to ask for questions, comments. Nina?
Thank you. On the subject of sexual offenders, to be quite honest, I'm not sure the Polish solution is so bad. I mean, yes, it sounds dreadful that they might spend decades imprisoned or institutionalized, but at least it prevents them from committing the crime again. Because I talked once to a person who has a lot of experience, who is in fact a prison psychiatrist, and who said that very often, particularly with sexual offenders, rapists, they, the psychiatrists, are quite aware that the person is not technically sane, that there is an underlying cause that is forcing them to commit their crimes, but they do say that the person can be considered responsible for their actions, because if they don't, then they won't be convicted. They will just have some measures of being institutionalized or mandatory psychiatric surveillance, which are very weak and will lead them to be free and committing crimes again sooner. So they technically very consciously lie about the patient's condition precisely to prevent the patient from reoffending. I don't think that's a particularly good systematic solution. And just one remark, generally, of course, we all had reactions here in the room. You couldn't see us, but when you saw when you showed the slide with the number of 200 inmates per prison psychologists, of course, that's way too few. And I think that is generally the problem in modern states with investing in numbers of needing experts. Everyone is complaining about the slowness of judicial procedure, but nobody wants to say, well, we need 20 times more judges. Everyone is complaining about the quality of education, but nobody wants to say, let's pay for 10 times more teachers and professors. So I'm afraid that's a general systemic problem. Thank you.
Thank you very much for your opinion. In the case of the Gostynin place, I really recommend the article. I believe it's written in English also, by Monika Płatek, and she shows the infringements of law in there, because I agree with you that sometimes it's just the only option to isolate someone from the society. And but there is issue with overcrowded rooms, with conditions that do not help the prisoners. Yeah, and another issue is that we don't exactly know what is the status of the person there, because it was not created to help people with mental disorders, but it is not also a prison. The whole concept of this place was created very spontaneous, and there's a lot of things that need to be repaired there. But I believe that, yes, sometimes the isolation of the criminals is the only possibility to help the society. And yes, I agree with you with the statement about the current problem of not enough staff to help the prisoners to receive adequate psychological help, and yeah, the whole help. Thank you very much.
Thank you. Any other question, Professor?
Thank you. Oh, that's okay. No worries. That's for everybody's betterment, if I'm not anyway. Thank you very much for the paper. I'm Coleman Dennehy from Dublin in Ireland. And just on the matter of the discussion there earlier, in Ireland in the last kind of 30, 40 years, we've increased our sentencing for sex offenders, both against children and against adults, fairly considerably. I'm not sure how it would compare to Eastern Europe, but it's reasonably high compared to Western Europe at least. And we do have one specific prison where sex offenders are kept. Usually they have to be segregated from other prisoners in Irish prison society, because there's kind of, in the prisoner mentality, there's good prisoners and there's bad prisoners, and people who offend against children are the worst possible. But what we do also have, though, is we do have a a specific treatment program, and it requires the offender first and foremost to acknowledge not just that they've broken the law, but that they've caused harm. And it needs to be a very genuine sort of reflection on the fact that what they've done is actually wrong in the sort of ethical sense, not to mind the legal sense. But then if they engage in that program, figures for what in the Irish legal system we call recidivism, basically meaning reoffending. The rates for sexual offenders who reoffend are actually the lowest of all of our crimes in Ireland. So there's a much better chance of producing a reformed character who was previously a sexual offender than somebody who might be violent in a conventional sense or property crimes or whatever else. And it would suggest that there are, now it takes real courage by politicians. It's a very uncomfortable conversation generally for society, because society generally wants to hurt people who have done these most heinous crimes, and they really want them to suffer and they want longer sentences. But at the same time, if you want to actually improve the society and make it more safe, if you have a program of treatment, I think it's mostly psychological. Things like therapy, sitting around in a circle saying, I have a problem and I've done something terrible and I'm going to try my best to. And it, like I say, it takes place over a long period of time because the sentence is quite long. But if you can drop the level of reoffending, then surely that's a win for society generally. And also, obviously, for the potential future victims who may not be victimized as a result. But like I say, it's a very uncomfortable conversation for society generally, and for the newspapers and for the politicians to have, to say we're going to throw money into a program that's not actually harsh or vicious or violent towards these offenders, but is going to treat them more as patients than as criminals, you know. It's just a thought, but like I say, it's a very difficult conversation to have generally. So it's not a question, just a comment, really.
Thank you very much. Thank you very much for your opinion. Yes, I agree. I believe that we are not just helping them, we are helping the society. And thank you very much. It's very interesting.
Thank you. We have another question or comment.
Can you describe the situation in Poland in the first year of prison, in the first year of development prison? Because for me it's very interesting. In this year, Poland is divided between Austria-Hungary, Germany, Germany and Russia, and this is three countries with very different legal systems. And for me, it's very important. And second, I want to add about Nina comments about assistance, psychological assistance. The situations in all area of public, all area of legal system is very critical, but in psychological assistance is almost is very, very critical. This is the most critical area, because I think we have some shame about psychological assistance. We need psychological assistance in every circumstances, but we don't want to accept this. For us, for our culture, psychological assistance is something very shame. And I see a problem in it.
Okay, thank you very much for the questions. Excuse me, could you just repeat the first questions? Because I am not sure if you asked about the prison situation during the partitions of Poland, yes? Is it that?
The prison situations in the beginning of 19th century in Poland.
Okay. First of all, I don't know a lot about this topic, so I don't want to say something what is unhistorical. But what I've heard about it, that the worst prisons situation was in Russia. And in the German and Austria, we had more codification. And in Prussia, there was the most most numerous codification about this topic. yeah, and I believe that I just would have to search a lot more about this to tell you briefly. But generally, we had small awareness of the human conditions in prison those times.
Thank you. Thank you very much.
Thank you.
Any other question?
Thank you. My name is Sofia Lekic, University of Belgrade, Faculty of Law and Faculty of Political Science. And my question concerns the difference between those who commit a crime while mentally ill and those who develop a mental illness after committing the crime, who are therefore guilty for the crime. Concerning their treatment, is there any difference between the two categories, or are they treated the same in the mental facilities? And what is your opinion? What would be the best solution regarding that? Thank you.
Yes, so firstly, I've read that, thank you very much for your questions. Firstly, I've read that in Poland, it's not very popular and possible to always be excluded from the punishment because of the mental illness. It's very strictly perceived, and it's not very popular to exclude someone from the possibility of enforcing criminal liability. So the first issue is a contratype, which makes it person does not commit a crime. And when someone commits a crime, so he's able to recognize the meaning of his behavior during the act, he committed the crime. Sometimes he can have a mental disorder, and which is not very vivid while committing the act, but after, for example, when he is in prison, the Polish Executive Penal Code states that we cannot create a danger for himself, for him, when he's in prison, because he's not mentally able to be in prison. And then he should also be in a psychiatric hospital and receive adequate psychiatric care before being able to serve his prison sentence.
Thank you.
Thank you.
If there is no other question, I suggest to switch to our last speaker. Before that, thanks a lot, Sara, for your very interesting presentation. You could see that many of our colleagues were very interested in many questions concerning your topic. So I hope you will deepen your knowledge and divide with us in our future conferences, either here or somewhere else.
Thank you,
Thanks a lot.
Thank you very much.
And our last speaker for the 8th session is Katsiaryna Vayda from the International University MITSO, Faculty of International Law from Belarus.
Hi. Can you hear me?
Yes, but I cannot see you.
I turned on my camera. You should be able to see me.
Yes, now we can see you.
Yes. Unfortunately, I do not have a presentation, so just hear me out by words. So my topic is international responsibility for the violation of the refugees' right. The international responsibility is a very special institution that differs from the responsibility under domestic law. And the difference is in the mechanisms. The international legal norms and principles themselves serve as a guarantee of compliance with the international legal order. Since each state is a sovereign unit in international communication, the regulation of the international relations is carried out collectively by the states themselves. International law has the long-known such general principle according to which any damage caused by must be compensated. The final part of the first written bilateral agreement that has come down to us, the Treaty of 1296 BC between the Egyptian pharaoh Ramses II and the Hittite king Hattusili III, provided for a kind of sanctions for its violation. May the house, the land, and the slaves of the one who breaks these words perish. This formula expressed the consequences for the violation of the contract. And this also proves that the institution of international responsibility was already given great importance in distant times. But nowadays, it is very important to put responsibility for the violations of the norms and principles of international law for crimes against peace and humanity, violations of fundamental human rights and freedoms. The preservation of peace and the protection of human rights are closely interrelated. Violation of fundamental human rights always leads to adverse consequences. They cause people to seek asylum in other states. Therefore, respect for human rights as well as the knowledge of international human rights law is a necessary condition for preventing refugee flows and solving related problems. Asylum seekers and refugees have all the rights and fundamental freedoms proclaimed in international human rights treaties, and the central element of international refugee protection is the right not to be forcibly returned to the circumstances that could endanger someone's life or freedom. Modern refugees flows are very often not the result of direct persecution. The reasons for seeking refugee at present include also ethnic conflicts, natural disasters, and extreme poverty. And as a result, many of today's refugees are not covered by the definition contained in the 1951 Refugee Convention, which excludes only victims of persecution on the basis of race, religion, citizenship, belonging to a certain social group or political beliefs. And this definition is relevant for the situation of the post-war years and does not take into account many of the situations that occur today. And as a result, many countries, especially in Africa and Latin America, have expanded the definition of the term refugee. However, in the majority of countries, these applications are getting rejected on the basis of a strict interpretation of the definition. Refugees also are more likely to face human rights violations. So the Office of the United Nations High Commissioner for Refugees was created to protect the rights of refugees. So the main task is ensuring that refugees are not forcibly returned to the country where they have reasons to fear for their lives. Also, the present situation is such that it is quite difficult to ensure full compliance with international human rights standards. The mechanisms of international responsibility that already exist compared to the measures used to enforce the norms of domestic legislations seem weak and ineffective. So the international legal responsibility is a negative legal consequences that occur to the subject of international law as a result of violating an international obligation. Subjects of international legal responsibility are only subjects of public international law. So a state is only responsible for human rights violations in the international arena only if it has failed to provide the alleged victim with adequate and effective protection through its courts or administrative authorities. International legal responsibility occurs for the commission of an international human right offense. It is the application of sanctions of international legal norms to the offending state, and usually is associated with certain negative consequences. It is also aimed at ensuring international law and order in the event of a massive and systematic violation of human rights. To sum up, the refugee problem and the problem of the protection of human rights are closely connected, and it is a challenge to the international community. The states, the hosting states, must continue to fulfill their obligations to ensure their protection and contribute to the creation of an environment of tolerance towards the refugees, and the states of the origin are obligated to prevent actions that give rise to mass departure of the population. Thank you for your attention.
Thank you, Katsiaryna, very much. As I said, this topic of refugees is very actual also in Serbia today because we are faced with this phenomenon. And I would like to also ask for comments or questions. Is there any comment? Aha, sorry.
Thank you for your presentation. Thank you for your presentations. And I ask you, what is your opinion about the concept of safe third country? Because the list of safe third country is held by government in many countries, and many countries proclaim safe third countries and return migrants and refugees in countries which is not safe for them.
Can you repeat your question? I don't seem to understand your point.
What is your opinion about the concept of safe third countries and the list of safe third countries?
Well, my opinion is, what countries can you repeat?
About the concept of safe third countries, about returning refugees in countries from which they came.
The colleague asks you what is your opinion concerning the problem of pushing back refugees to the country of their origin. So
so the return of refugees. In my opinion, it is unacceptable to return refugees if the danger is not gone, because usually they quit their country for a reason, and you cannot be sure that the situation that they left is not going to happen again. So this way, only the person who is a refugee can decide when they are ready to return to their state of origin.
Excuse me, I'll try to explain, because that's not what the colleague meant. He said safe third country. So sending a refugee not to his country of origin, but neither keeping him in the country where he is right now, but returning him to a third country where they would be safe. So that's usually taken to be the first country that they escaped to, if there are no problems with persecution, etc., in that country. So assuming someone flees from, I don't know, Iraq and first gets to Italy and then to England, and then England says, well, he's okay in Italy, return him to Italy.
So you mean to send a person to a third country, not his the state of his origin?
Yes.
I think it is acceptable because it is not always possible to hold all the refugees, all the flows. So this way we can spread the refugees flows to more accepting countries, and also this way we can provide them with more suitable accommodation, so to say.
Thank you.
Thank you, but I would like to ask, what if the political attitude, for example, as as the situation is in Italy now, where refugees are not welcomed, at least refugees from Africa. How can we impose to the third country this duty to accept refugees if political attitude is no, we won't accept refugees?
Well, usually there are certain agreements that are made so that the accepting country is willing to take those refugees, because we cannot force on a third country these obligations.
Of course, but what is it effective, the measure to settle them wherever we want? Because it can happen that no one country wants to accept refugees. This is a hypothetical situation, but we are of course faced with a possible problem if because situation, unfortunately, political situation in Western Europe, it seems to me that it's very close to some trend in not accepting refugees, that we want to restore somehow our national states. I think this problem will be a big problem in the future, especially for those refugees, as I said, who try to escape from poverty and not from political causes like wars nowadays in Ukraine. Thank you. Is there any other question, Georgie?
Thank you, Katsiaryna, for your presentation. I would just like to leave a remark, considering that European Union is probably the most struck by refugee crisis, and the problem is when we are applying the concept of international legal responsibility stricto sensu, the most hit countries would be or are Italy, Greece, and Spain, and it's the problem of it's the problem of European Union not distributing the responsibility for the refugees, but leaving for the countries that are the SADAs, that are borders of European Union, to deal with refugees. And once they simply can't accept that much, for example, asylum seekers or refugees, they naturally breach. They will naturally violate their rights at some point. So I think that we should, I mean, European Union should be thinking of some mechanism to distribute the responsibility, as they did with Poland accepting asylum seekers from the current situation in Ukraine. So what's your opinion on that, and do you agree with me?
I understand that accepting refugees is not always pleasant, but in order to keep the peace, we have to do it. And there are big waves of refugees connected to some events that are happening, but I think that we should all help each other, and this way we can prevent even bigger issues.
Thank you.
Thank you. If there is no other questions or comments, Katsiaryna, I would like to thank you.
Thank you
And I
too
hope
for
in the
your
future
attention.
we will solve in the best way all these problems concerning refugees in a
Thank you.
way that we can be all satisfied. Thank you once again to all, especially for the participants of this 8th session. And now I would like to invite you for our lunch break. As you know, in our club, Nina wants to say something.
Just before that, since this is our last English session, after lunch we have 2 more Serbian sessions. I would like to thank our international participants who probably won't be joining us for the papers that they don't understand afterwards. So thank you all for coming and for participating online. We really liked your papers. We hope you will come again next year, or those of you who couldn't come in person, that you will come next year. And naturally, please send us your papers for the Herald of Legal History. We'll be happy to have them, and generally stay healthy, stay in touch, and see you on some other occasion. Thank you all.
Thank you.